बिस्मिल्लाहिर्रहमानिर्रहीम। आज हम अपने उस्ताद मोहतरम जनाब मुताहिर तिरमिज़ी साहब से इर्रिवोकेबल पावर ऑफ अटॉर्नी के टॉपिक पे डिस्कस करेंगे और बाकी सब भाइयों के साथ मिलकर हम रिक्वेस्ट करेंगे कि आज इस पे हमें अपना नॉलेज शेयर करें और इसी पे ही गुफ्तगू जारी रखें। थैंक यू सर, आप शुरू करें।
Gentlemen, irrevocable power of attorney is a very important topic. The lawyers usually have to determine whether a power of attorney is revocable or irrevocable. For the purpose of determining this factor, they must be aware of the distinction between revocable power of attorney and irrevocable power of attorney. There are two kinds of power of attorney. One is called special power of attorney and other is called general power of attorney. Special power of attorney gives special powers while the general power of attorney gives the general powers. In Pakistan, according to the constitution, every citizen has a right to own property. The person owning the property has every right to administer it, to look after it, to enjoy it, to dispose it in any manner he likes. So the rights of a citizen are protected and he is owner of the property and he can administer the same. Suppose A lives in London but he has property in Pakistan. Now the question arises as to how he will administer it, how he will look after the land, how can he reap it, reap the harvest, and how he can plow the fields, how can he occupy the same. The man living abroad must not be having the power to do so. So the law prescribes a mode for the purpose of taking stock of this situation and meeting it. He can meet the situation through delegation of powers to other persons. Contract Act provides that a person is entitled to delegate his powers regarding his land to any other person. So the person delegating his powers is known as the principal, while the person to whom the power is delegated is called an agent. So the delegation of powers is through a power of attorney. Through a power of attorney, all such powers which the principal desires may entrust to the agent. So originally, this is a doctrine which enables a person living abroad or out of the place where he intends to administer the land. So if he wants to take stock of the situation and if he wants to keep an eye on his property, he is authorized to appoint any person as his attorney. So a person of sound mind who has attained majority may delegate his powers to any person to administer his property as an attorney. So the attorney is known as his agent. So when a power of attorney is executed in accordance with the law, then an agency is created. When there is an agency, Both parties have mutual rights and liabilities. Under Section 201, an agency may be terminated. How it can be terminated? It may be terminated by the death of either party. If the principal or the agent dies, the agency is extinguished and power of attorney is terminated. By the mutual consent, they may revoke it. Even the principal himself alone has the authority to revoke the same. The agency may be terminated by the principal without assigning any reason for that. So sometimes it happens that an attorney is appointed for a particular purpose. When that purpose is achieved, then the work of the attorney is over. Then his liability extinguishes. So the power of attorney is terminated on the completion of the job which was entrusted to the attorney. So in this situation, all powers are given to the principal to terminate it. But there is a situation when the principal cannot terminate it. That situation is called that the power of attorney is irrevocable. And the power of attorney which cannot be revoked is known as irrevocable power of attorney. It usually happens that in general power of attorneys, this word is added. General power of attorney irrevocable. Sometimes in the body it is written that the principal shall not be entitled to revoke it. So it is irrevocable power of attorney. But it is not sufficient to write it. Even in certain situations, even if it is not written, even then the power of attorney may be irrevocable. So the revocability or irrevocability is dependent on the contents of power of attorney. So section 202 states that the power of attorney shall not be terminated if an interest is created in favor of the agent. Meaning thereby, if the agent has an interest in the property, the power of attorney cannot be revoked. Here we are to draw the distinction between ownership, title, right, and interest. It does not mean that the agent is the owner of the property. It does not mean that he has a right to retain the property. It does not mean that he has a title in the property, but it is only the interest which is sufficient to make it irrevocable. For this purpose, a very competent judge of Karachi High Court gave a very good authoritative pronouncement on the subject, and I would like to refer the same. That's in 1979, PLJ 1979, Karachi, page 52. It is one of the most important authorities. I would like to refer it to you. Section 202, Scope, Principal and Agent, Agency, Termination of interest of agent in property forming subject matter of agency, agency not terminable to prejudice such interest is absolute express in absence of any contract. Interest may be inferred from language of the document, as I stated, not from the words of revocable or irrevocable, but from the language of document and course of dealings between parties and need not be express. It is not necessary that it should be written on the document that is irrevocable. There may be certain examples when the word irrevocable is not written. Even then the power of attorney is irrevocable because it shows an interest of the agent in the subject matter. Further, agreement to sale and power of attorney executed on same day in course of same transaction. A man is owner of the property. He enters into an agreement to sell with B and received certain amount from him. And along with that agreement, he also executes a general power of attorney in favor of the vendee. So the law says that when the power of attorney is coupled with an agreement to sell, in spite of the fact that it is not written irrevocable, it becomes irrevocable. So the only point which requires determination is that there should be an interest of the agent in the subject matter. Further held, applicant having got into possession of land for value paid and acknowledged in agreement and having right to usufruct till final transfer of land, his power of attorney cannot be revoked by respondent in view of existence of interest in land forming subject matter of document. So when this type of interest is created, generally we saw that the death of the principal results in the termination of agency. But in this situation, even if the principal dies, the authority is not revoked. Power of attorney is not terminated. So you are to go through this authority with care, and you will find several important things in this authority, how an interest is created, how a power of attorney becomes irrevocable. Now, if we study section 202, we find that there are two aspects of this. There are two parts. The first part contemplates that the interest of the agent himself should exist in the property that forms subject matter of agency. The second part of the section is that when such an interest is created, it cannot be terminated to the prejudice of agents unless expressly provided in the document. So the main point which makes the power of attorney irrevocable is the interest of the agent, not the title of the agent, not the right of the agent, but only the interest of the agent. Only when there is an interest in the subject matter, the power of attorney becomes irrevocable. As I gave you the example that if there is an agreement to sell, along with general power of attorney, it becomes irrevocable. And even after the death of the principal, it does not terminate, it still exists. Some jurists are of the view that it amounts to a sale. When an interest is created and the money is paid and the possession is delivered along with general power of attorney, this power of attorney is not a simple power of attorney, but it is a sale deed. So when it acquires the status of a sale deed, it shall mean that the moment the principal becomes the owner of the property, the agent shall automatically be the owner of the property. So this is the basic concept. How it will be determined? Number one, there must be agency. If there is no agency, then there can be no power of attorney. Power of attorney creates the agency. The subject matter of the agency must be some property. So there should exist some property for making the general power of attorney as irrevocable. So, but if there is no property mentioned in the document, then it is not irrevocable. If there is description of the property as a subject matter, then the power of attorney, if creating an interest in the agent, then it becomes irrevocable. The agreement must have the agent must have some interest in the property. Without interest of the agent, there can be no irrevocable power of attorney. Suppose a suit is pending in the court. A is unable to appear in the court. He gives special power of attorney to depose in the court. Then there is no subject matter as a property. The property is not subject matter of that document. The money is not involved in it. Possession is not involved in it. So this cannot be irrevocable, even if you write that it is irrevocable. So writing of revocability or irrevocability does not affect and is not a determinative factor. The determination is dependent on the contents of the document, not on the heading of the document. We several times saw that it is written general power of attorney irrevocable. But the contents show that there is no interest of an agent. So in spite of this writing, it shall not be irrevocable. So irrevocable becomes only when the interest is created. There are two important authorities. 2009 YLR, page 334. Interest of agent. Effect. Provisions of Section 202 of Contract Act 1872 can be split up into two parts. It's a very important matter. First part contemplates that interest of agent himself should exist in property that forms subject matter of agency. And there is a second part as well. Second part is that when such interest is created, it cannot be terminated to the prejudice of the agent. In first place, there already exists the interest. In the second part, the interest is created. There is a slight distinction between the two parts, unless it is expressly provided in the contract. If a power of attorney is irrevocable and in its another condition is imposed that under certain circumstances it shall be revoked, then those conditions will prevail. So the condition precedent shall prevail in the determination of general power of attorney as revocable or irrevocable. Then there is another authority, 1997 CLC 1903. Section 202 applies only when an agent has a special kind of interest. What kind of interest that may be, it is explained in it. Pre-existing interest in the subject matter of the agency, which is sought to be protected through creation of agency. There is an interest and that is to be protected through that agency. If there is an element of protection of interest, it becomes irrevocable. Such contract, however, in certain exceptional circumstances, can be considered irrevocable. Another authority, PLD 2007, Karachi 278, Section 202 lays down an exception to the general rule. A contract of agency, by its very nature, is personal to his parties and revocable at their will, subject to agreed terms. It is general principle that a power of attorney may be terminated at any time by the principal, but Section 202 is an exception to this rule. It gives protection to the agent, that if there is an interest of the agent in the subject matter, he should be protected by declaring this power of attorney as irrevocable. So, when the power of attorney is irrevocable, it creates interest or it also declares the existence of interest, and the person having the interest shall be entitled to enjoy that interest till this power of attorney exists. So when it is irrevocable, there is an authority in 1979, PLJ page 52, that even after the death of the principal, the power of attorney holds the field. If the power of attorney is irrevocable and the principal dies, it doesn't matter. The general attorney shall still exist and he shall exercise all the powers given in the document, in spite of the fact that the principal is dead. So, irrevocable power of attorney is tantamount to transfer of rights. Although it does not declare that there are rights, but the consequence is that the interest becomes the right of a person. So, in spite of the death of the principal, that right cannot be taken away. A person having irrevocable power of attorney may dispose of the property even after the death of the principal. He may write in the sale deed that Mr. Such and Such was the principal, he died on Faran date, but the power of attorney is irrevocable and it amounts to sale deed in my favor, so I am going to dispose of the property. He can recover the money, he can deliver the possession, he can get the mutation sanctioned. So when the power of attorney is irrevocable and during the subsistence of that power of attorney the principal dies, it shall not affect the rights of the agent. Irrevocable power of attorney creates an agency coupled with interest. When agency is coupled with an interest, it is known as irrevocable power of attorney. So Section 202 is in fact an exception to Section 201. 201 gives the powers of termination to the principal. 202 takes away the powers of the principal to revoke it. So how it is to be determined? It is to be determined from the contents of the document and the creation of interest in the subject matter. So being lawyers, it is our duty to go through the document and find out what type of document it is. After determining it, we are to proceed further. Bundle of thanks.